How you doing, sir?
I'm fine. Has Mr. Strickland spoken? Has he spoken to his attorney yet?
No, he hasn't.
Okay. She's in a breakout room with another person, and as soon as she's done with that person, I'll put you in the breakout room with Mr. Strickland. So it'll be a few minutes, okay?
Okay, sir. I just want to let you know he's not consenting to do a video arraignment.
So what is he consenting to do?
I'm getting him his paper. Is there any paper clips or anything?
Oh my God.
Yeah.
Okay.
Yeah. This is the court, sir.
I don't consent to the thing. I'm asking why they can't bring me court.
Okay, hold on. Does he want to speak to an attorney first?
Yeah, well, let's have him speak to an attorney first. You have to speak to an attorney. You have to.
Hold on. Mr. Strickland? Mr. Strickland, can you hear me?
I don't need an attorney.
This is the judge.
Okay, Mr. Strickland.
Open the door.
Can you hear me?
Can you hear me?
You don't want to hear me.
Sir, can you hear me?
What?
Mr. Strickland, this is Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand? I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity. So y'all trying to run a lien on the name, that's illegal. Who are you trying to conversate with? The name entity or the flesh and blood man?
You tell me.
I demand to be released on my own reconnaissance.
All right, guys, buckle up, because today we're diving straight into the legal circus unfolding in Michigan, where two self-proclaimed sovereign citizens attempt to outsmart the courtroom and crash headfirst into reality. This first hearing kicks off as an in-custody arraignment. On paper, it should be simple: confirm identity, advise rights, determine bond. But instead, it detonates into ideological theater. The defendant refuses to cooperate, refuses to recognize authority, and immediately demands release, as if shouting legal buzzwords somehow overrides the judicial system. What we're about to witness isn't strategy. It's self-sabotage in real time. The court attempts calm professionalism. The defendant chooses confrontation. And within minutes, the entire hearing spirals into a showcase of confusion, defiance, and predictable consequences. Let's break this down carefully, because this is where the meltdown begins.
I have a UCC1 here. I've laid claim to the name entity through the Secretary of State and the federal government. Here it is right here, the Secretary of State, just
okay. Sir?
It's right here, Lincoln. To the flesh and blood or the name
Sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you speaking with? The flesh and blood man or the name entity?
I'm speaking to both of y'all. I'm speaking to both of y'all at the same time. How about that?
You can't.
Now, sir, I know you want me to release you.
Here it is.
Are you gonna let me talk?
Here.
Are you gonna let me talk? Sir?
Sir?
Are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down,
Don't
sir.
consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yeah.
Want to release you, the entity, or the person in the flesh? Which one?
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right, now.
For UCC1, everything.
If you don't, when I talk, you listen. If you don't want to talk to an attorney and you don't want to be arraigned today, we're going to put you over to tomorrow. You understand that?
So we already been through this. I am the executive of the account.
Okay. Have a good day, sir.
The magistrate, identified as William Burton, attempts to perform the most basic procedural task, asking whether the defendant wants an attorney. That's it. A yes or no question. Instead of answering, the defendant launches into the classic sovereign citizen script. Are you speaking to the flesh and blood man or the name entity? And just like that, the courtroom transforms into a word game battlefield. He claims to be the executive of his legal name entity, insisting the court is targeting a corporate fiction. He waves around references to a UCC filing, as if commercial lien paperwork somehow dissolves criminal charges. The judge remains composed, but firm. This isn't philosophy class. It's an arraignment. And when someone refuses to engage in reality, the legal system doesn't collapse. It simply moves forward without them.
Now calling case number 24W001656. This is the Township of Ypsilanti versus Shannon Phillips.
Hi,
Hi, can you state your name for the record, please?
Shannon Phillips.
Okay, thank you very much. So today is the date and time set for an arraignment in this matter. What I have here is a citation from May 27th of 2024 that charges that on or about that date you did operate a motor vehicle on E-Course Road at or near Harris Road with improper plates. It says that the plate did not come back to the vehicle that it was on. That is a misdemeanor with a maximum penalty of up to 90 days in jail, a $500 fine with court costs, or both. Do you understand all that?
No, I do not understand.
Okay. So let me clarify. When I ask if you understand, what I want to know is, do you know now what you are being charged with, whether or not you agree with it?
No, I do not agree with it. And I filed paperwork to the court
Yes.
expressing that.
Okay, and I'm cutting you off for a second because I'm not asking if you agree with it. I'm just asking. I have explained that you're being charged with having improper plates. Do you understand that that is what you are being charged with? Again, I'm not asking if you agree with it. I just want to make sure, because the purpose of this hearing is to determine whether or not you are competent to stand trial. That's part of it, at least. Do you know what you are being charged with now?
Yeah, I see it on the paper.
Then comes the demand. Loud, repetitive, confident. I demand to be released on my own recognizance. But here's the problem. You don't unlock jail doors with declarations. You unlock them by participating in the process. The defendant refuses to consent to the hearing, refuses an attorney, refuses to answer plainly, and yet expects immediate release. That contradiction is the heart of this entire movement. Sovereign citizens claim the system has no authority over them, while simultaneously begging that same system for favorable treatment. The magistrate makes it crystal clear, no participation means no progress. The hearing gets postponed. The cell door remains closed. And just like that, the man who believes he's outsmarting the court has only delayed his own freedom. Aggression without understanding is not power, it's self-inflicted damage.
You do have the right to remain silent because anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. You do not have to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if these proceedings would have any effect on your citizenship status. If that does not apply to you, then do not worry about it. So, do you wish to have the public defender speak on your behalf?
No.
Okay. In regards to the misdemeanor charge against you, how are you pleading at this time? Or are you standing mute?
Standing mute.
Okay. I am going to set this for a...
Ma'am,
Yes.
this has been long and drawn out since, May. I don't even have that vehicle anymore. Unfortunately, I've had to buy 2 vehicles since that vehicle. Not to mention how aggressive and threatening your officers was when they approached my vehicle. Not to mention they were pulling on my door, yelling and screaming for me to get out or they were going to pull me out.
After the chaos settles, the reality is simple. Arraignments are procedural gateways. If you block the gateway, you block yourself. The judge even hints they'll try again the next day, offering another opportunity to cooperate. But here's the brutal truth. Courts operate on structure, not slogans. Refusing to answer questions doesn't make charges disappear. Filing paperwork with the Secretary of State doesn't override criminal procedure. And yelling about entities doesn't erase jurisdiction. What we witnessed wasn't rebellion. It was dysfunction. And now, we pivot to the second hearing, because the confusion doesn't stop here. In another Michigan courtroom, a different defendant is about to demonstrate how refusing to simply acknowledge a charge can derail an entire proceeding. Round 2 is about to begin.
I do have that video on my phone. However, because my laptop is not working, I have to use my phone.
Okay. Before you continue, couple of things. One, I will note that the officers are not court employees, so they are not the court's officers. What I am going to do, because it is the next step in this process, is set you for a pretrial. Okay? The purpose of the hearing today is to make sure that you know what you're being charged with and what the potential penalties are. The next step is a pretrial, which is where you will get to discuss with the judge more of what happened that day, and if you have evidence, then you can bring it up then. Your pretrial is being scheduled for November 27th.
Just a waste of time. 11/27.
Correct. This year, so that's 11/27/2024. That will be at 9 in the morning over Zoom before Judge Washington. Because of your appearance here today, I am recalling the bench warrant that issued for your arrest on October 9th. That bench warrant had issued because of failure to appear for a number of arraignment dates that were set.
But I was there and I have proof of that as well. I was on the hearing. It did the same thing it was doing now, saying that the host was there and would let me in. But I sat there for over like 2 hours on the 9th and the 10th and wasn't let inside the Zoom on either day.
Enter case number 24W656, Township of Ypsilanti versus Shannon Phillips. This hearing unfolds before Magistrate Bree, and once again, it should be straightforward. The charge? Operating a vehicle with improper plates, a misdemeanor carrying up to 90 days in jail. The magistrate calmly explains the accusation and potential penalties. But instead of confirming understanding, the defendant immediately resists. No, I do not understand. Notice the pattern? Agreement isn't required. Comprehension is. The court isn't asking whether she believes the charge is fair. It's asking whether she understands what she's accused of. That distinction matters. Because competency to stand trial depends on understanding reality, not rejecting it. After some back and forth, she finally acknowledges the charge. A small victory for procedure. But the friction is far from over.
I do have screenshots of that, so I'll present that as well at the next hearing.
Okay. So, to be clear, The bench warrant is being recalled, so that is going away.
Thank you.
The court is setting a personal recognizance bond, so basically you're promising to appear for the next court date. Again, that's November 27th. I will note that sometimes, depending on the size of the docket, it can take a long time. And I think my arraignment docket last Wednesday took 3.5 hours. So it can take a long time. So long as you're seeing the message that the Zoom is still going on and that the host knows you're there and can let you in, then as much as it is not a whole lot of fun, you should wait.
Okay.
Okay. So, do you have any questions right now?
Not at the moment. I don't believe so, no.
Okay, thank you. So, your next court date again, November 27th, 2024, 9 a.m. over Zoom before Judge Washington.
Okay.
Now comes the rights advisement. Right to remain silent, right to trial, right to counsel. Standard constitutional protections. Yet when offered a public defender, she declines. When asked for a plea, she stands mute. That triggers the court to enter a not guilty plea on her behalf, another procedural safeguard. But instead of moving forward efficiently, she pivots into complaints about the arrest, about officers being aggressive, about Zoom access issues. Here's the key detail: arraignments are not mini-trials. They are administrative checkpoints. Evidence arguments belong at pre-trial. The magistrate remains composed, explaining the next step, a scheduled pre-trial date. Structure, order, process. Even recalls a bench warrant issued for failure to appear. The system corrects itself. Calmly. Methodically.
All right, the court will call the matter of the Township of Ypsilanti versus Shannon Phillips, 24W001656.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Phillips. Your Honor, when I did speak to Ms. Phillips yesterday, she advised me that she did not want to be represented by the Public Defender's Office. Ms. Phillips, could you say your name, ma'am?
Ms. Phillips, please state your name.
Yes. Shannon Phillips, the natural woman. On the
Okay,
record and for the record, and let the record reflect. Can you guys hear me?
Very
It's saying
loudly.
I have an unstable connection. Okay. Just making sure.
So on October 9th, defendant was found in contempt of court. So that still stands, ma'am. You can choose not to have counsel if you want, but you need to understand that you can get up to 90 days on the contempt of court matter. Do you understand that?
I do not understand any charges. I only understand universal law and the right to live in peace and to live as I intend to.
But given that she doesn't understand,
Was never let in, just like now. But I obviously, I guess it took a minute. You administering the trust without consent?
I'm not going to be.
I'm having a bad connection. It's going in
I'm
and out.
not
I'm
going to
not
be
hearing nothing
releasing
you
the
all are
public
saying.
defender's office from this case because I don't think she fully understands the consequences of her actions, and so she will continue to have the public defender.
I don't
you.
need a public defender, Judge Washington.
Clip 6. But this saga escalates in the third hearing, now before Judge Washington. And this time, the tone shifts from patient to firm. Previously, the defendant refused to properly identify herself, leading to a contempt finding. Now, she faces consequences. The judge makes it clear, contempt can mean jail time. When asked if she understands, the defendant responds with abstract talk of universal law and living in peace. That's not a legal defense. That's philosophical poetry. Courts operate on statutory law, not cosmic vibrations. The judge insists she retain public defender representation, not as punishment, but as protection. Because when someone demonstrates they don't grasp procedural risk, the court intervenes to safeguard their rights. That's not oppression. That's due process.
Ma'am, I asked you a simple question and you did not answer the question in a way that makes me feel comfortable that you don't understand that you understand the laws of the state.
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied, ma'am. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness. This is
the charges?
You cannot make me have an attorney.
Well, actually I can, ma'am.
Like, this is insane.
Well, I don't think it's me that's being insane.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction expired plate.
Your Honor, I'd be happy to go into a break-in with Ms. Phillips and explain that to her.
Right. I will let you do that.
Thank you, Your Honor.
You're welcome.
Traffic infractions are not a crime. The